really, as far as the government is concerned. It's more a question of them trying to extend the olive branch in some form or manner.
Whether laws that were accepted internationally have not been implemented. For example, with respect to equalization levy, there were specific carve-outs made for
I wouldn't go for it. Mauritius should strongly resist it because this would mean undermining.
I think that these are challenging times because if we look at the MLR.
Hello and welcome to Juristconsult Chamber's second tax webcast. I'm Joanne Haig, head of the tax practice. Today we're going to be talking about BEPS and its potential impact on Mauritius. So what is BEPS? In a nutshell, the BEPS project is about preventing the shifting of profits from high tax to low tax jurisdictions, away from where the value is created. The primary objectives of the BEPS project is to ensure that multinational corporates are paying their fair share of taxes. But the reality of the BEPS project is of course much more complex and technical than that. The BEPS action plan is a huge project spearheaded by the OECD and endorsed by the G20, culminating in October 2015 in 15 action plans aimed at reorganizing how global businesses are taxed. However, let's not forget the dark side of BEPS. All the recommendations of the BEPS package aren't necessarily what's best for the global economy. The package may have been drafted with tax in mind, but have all the consequential implications been examined? I'm not so sure. And of course, let's not forget the eternal debate of the morality of taxation. Should we have a moral obligation to pay taxes even where it is legal not to do so? Are the good guys really the good guys? So here we are, 15 reports totaling over 1,600 pages of analysis and recommendations. Although not designed primarily with offshore financial centers in mind, the BEPS project will undoubtedly have a significant impact on the global business industry in Mauritius. The extent of the collateral damage will depend on the implementation in practice of the action plans. So, which of these are most likely to affect Mauritius? Action 6 is about the treaty abuse, and as I'm sure you're aware, this is a very sensitive issue for Mauritius, especially in the India context, even more so now. Action 2 is about hybrid mismatches. This concerns arrangements which result in double non-taxation. For example, when an item is considered as a dividend in one country and interest in another. Action 3. Control foreign company rules. These rules are about taxing profits of subsidiaries located in low-tax jurisdictions, even where the profits aren't repatriated. Mauritius could be seen as a CFC jurisdiction because of our deemed foreign tax credit rules. Action 15 is the famous and unprecedented multilateral instrument that is currently being negotiated by many countries, including Mauritius. We will be exploring some of the issues arising from the action plans in this webcast, so sit back and enjoy. The Indian budget was recently announced at the end of February. I really like the way NDA summarized the budget, worth an Oscar or two but not a clean sweep. One area of continuing uncertainty is the retrospective tax on indirect transfers. Once again, the Indian budget did not address the question head-on and proposes a solution that only seems to be helping the Indian tax authorities tax more quickly rather than going to the crux of the issue. Why the constant delay and deferral?
So I think as far as the government is concerned, they're in a bit of a bind, purely because they can't be seen to be taking a decision which favors non-resident taxpayers in this case, whether it's over the phone or a team. So which is where they're sort of stuck. The ideal situation, and if you look at the budget speech, it actually comes out. The ideal situation for the government is for the courts to have actually decided the matter. If the courts had struck down the provision, I think the government would have been just fine with that. But at this point in time, really, as far as the government is concerned, it's more a question of them trying to extend the olive branch in some form or manner, whether it's for Vodafone, whether it's for Keen or any of the other cases. And more than anything else, try and send the message to investors that they are trying within the set of limitations which they have. The set of limitations being that they cannot go ahead and directly make an amendment to say that the provisions will only apply in a prospective manner, because that will raise a hue and cry the next time they get back into parliament. So I think that's where they're trying to walk the thin line. Hopefully, in the government's ideal case situation, either some court or actually strikes down the provision, in which case they know that that they can actually point out to a judicial process which overturned the provisions rather than a political process.
Thank you. Two items of the Indian budget that stem out of the BEPS package is the equalization levy on online advertising fees to non-residents and country-by-country reporting. Did you perhaps expect more of BEPS to come out in this year's budget?
Yes, we did. This is the first budget that has been passed after India accepted to implement the BEPS package. And what is disappointing, however, is that in implementing the BEPS package, particularly the equalization levy and the country-by-country reporting, they have not adhered to the international standards, particularly the safeguards that were accepted internationally have not been implemented. For example, with respect to equalization levy, there were specific carve-outs made for jurisdictions that were not low-tax jurisdictions. For instance, if the money was going to a low-tax jurisdiction, only then the equalization levy would have been made applicable. But such carve-outs do not exist under current Indian law. And even with country-by-country reporting, the confidentiality requirements which were which was meant to counterbalance the transparency requirements have not been taken care of under India. We hope that they'll take measures to rectify this as soon as possible.
Thank you.
Last question, and I know that's a key concern for many people in the industry. The last round of treaty negotiations between India and Mauritius was in March, and not a great success. No agreement was reached. In your experience, do investors continue to use Mauritius as a platform into India, or is there a particular preference for Singapore, which has a treaty with India with an LOP clause?
So I think two aspects to that. The first one is that the main concern which investors today have is the fact that general anti-avoidance rules are going to come into effect from 1st April 2017. So what next? As far as the past is concerned, in respect of any investments till 1st April 2017, the government has taken a clear stance, which came out in last year's budget, where the finance minister said that he's going to grandfather any investments which were made prior to the introduction of the card. So that so long as the investment is made prior to 1st of April 2017, that will still be given effect to, and the general anti-abuse rules won't apply to those investments. As far as the move beyond that, that's really where you get into a lot of ambiguity. The investor concern today is that at this point in time, yes, we are comfortable that we still can go down the path of investing using Mauritius as either the pooling vehicle or the SPV. But there are obviously concerns which have been raised, saying that should we look at it from a longer term perspective, should we move to Singapore or not? Should we start creating or building a base in Singapore instead of trying to stick to Mauritius? So those questions are being asked, and they will be asked till such time there is some resolution insofar as what is the path which India and Mauritius adopt, either in respect of the treaty, or what is the path that India adopts as far as application of the general anti-avoidance provisions. Statistically, yes, we are seeing a situation that probably much more investments are coming in from Singapore than what used to happen. But having said that, as I said, there is a 1 year period for which investors are still comfortable using Mauritius, but there is always a concern at the back of their mind as to what is the long term, is there a long term solution around use of Mauritius for investments.
Thank you very much.
So, Yamini, we're here also to talk about Action 15. So, this is about the MLI, which is a first in the international tax field. It will be the first of its kind, a global treaty amending all existing bilateral treaty. So, such a huge project is bound to pose some technical challenges. One of the best possible mechanisms under the MLI is the asymmetrical application of the provisions. What are your views on the matter?
So first of all, asymmetrical application, it can be applied to certain provisions. I mean, only one, as far as I'm concerned, it's the elimination of double taxation. The reason is simple, because it would be applied to a jurisdiction's own residents. However, applying the asymmetrical application to other provisions, like for instance PPT or LOB or any other provisions, I wouldn't go for it. Mauritius should strongly resist it, because this would mean undermining a fundamental principle of tax treaties, which is reciprocity. And in some countries, I know for instance the US, they do have asymmetrical application for some provisions, but it's always after there has been a bilateral agreement. So if ever we have to go for asymmetrical application on certain provisions, it's got to be essentially negotiated bilaterally.
Okay, thank you. So the MLI, as I said, is expected to modify existing treaties. So on the assumption that the MLI is signed by Mauritius, I think the plan is to sign it by the end of the year, will consolidated version of existing treaties be produced? How will this work in practice? I'm struggling a bit to understand here.
In my mind, we will have to go for consolidated versions. Because tax treaties, at the end of the day, they are used by a couple of people, like even us, tax administrators, the industry, the taxpayers. So you need a document which is actually user-friendly. And so what we will have to do is actually taking all these particular provisions, reviewing treaty by treaty, amending individual treaties, have it agreed with our treaty partner, then produce a consolidated version, have it ratified, gazetted, in such a way that this consolidated version will have force of law. I don't see any other way to go about it.
From everything you said, I mean, this is a huge task for Mauritius. Do you think we have the stamina for it? Do you think we have the resources for it?
Well, is there a way out?
Good answer. Thank you very much, Yamini. So Rajesh, thank you for coming today. So do you think the implementation of the BEPS package, and here I'm thinking in particular about Action 6, would that negatively impact the global business industry in Mauritius, in your view?
Well, the action point number 6 is about inappropriate use of treaties. And we have here in mind treaty abuse, treaty shopping, aggressive tax planning, and so on, which today have posed a number of problematic issues to countries in terms of tax base erosion there. So I think that these are challenging times, because if we look at the MLI, there are certain minimum standards there. And one of the provisions which countries will not be able to have reservations on or derogate is in fact this PPT, which is sort of the sort of lowest let's say threshold for tackling treaty abuse, the principal purpose test, or a more sophisticated LOB with an additional anti-conflict rule. So that I think that all 2,500 treaties in the world are going to be affected, if not amended, to include by default a PPT rule. And therefore, Mauritius will be also concerned by that. We will have to relook at the treaties and to revisit them, so that at least we have a PPT, and if we don't, it's going to be there by default, because we will not have a reservation on that. And I think it is better for us to decide, the soonest, whether we go for a PPT or whether we go for a more sophisticated LOB, including an anti-conflict rule. At the end of the day, all countries will be on the level playing field once everyone agrees on the PPT, because it's going to be there by default anyway.
Thank you. So from what I'm hearing from you is that it is coming, it's unavoidable. And do you think management companies should start shutting down, or is it all doom and gloom, or do you think that there's an opportunity for Mauritius there?
No, I think Mauritius has already made found its niche in the sort of scene of international financial services, and it's not only for tax reasons. I think one of the important selling argument for Mauritius is not only political stability, but it's legal stability. And investors like to have that buzzword, stability, because it brings with it predictability. In the short term, medium term, or long term, investment. And I think in the world, if you look at all the league tables, Mauritius does very well, if not topping in Africa. We are like in the top 10 in a number of governance related issues there. And that is the important, or most important selling argument there. I think that strong on those criteria, Mauritius has a good selling argument in terms of time zone, which we always say, in the middle of between the west and the east there. And I think when everything is going to settle, we are going to have these competitive advantages still there, working in our favor. And tax is something which is always important there. And in view of the international economic environment for the next, I would say 5 to 25 years, Mauritius is an interesting card to play, especially with Africa by our side, where we have a real sort of partnership with a lot of substance, because we form part of an economic group of 350 million in terms of what the COMESA presents. And I think this is a very important card we have to play. The fact that the growth generators are just next door.
Thank you very much, Rajesh.
Thank you.
The subject of BEPS is an important one for Mauritius, for the future of Mauritius, for the future of our international financial center, for the livelihood of lawyers, bankers, people involved in the corporate world. We are proud to be associated at the level of Juristconsult with shaping the future of Mauritius. For the last 25 years, when the Mauritian International Financial Center has been in operation, Juristconsult has always made an effort to be close to its client, to all stakeholders, so as to better find solutions for them and for our jurisdiction.
This is it for today's webcast. We hope you've enjoyed it. I'm sure there'll be more opportunities to discuss BEPS as things evolve throughout the year.